The 20th of March 2023. I promise this will be a short video. I'd ask you not to turn off because it does show you the progression of a campaign by a good few people, but very much centered around myself in many ways, and how we slowly but surely move to victory. Now, I've told you before that I have always said that all of the renewable energy programs and programs for energy by government must be assessed with public participation, the right to take a judicial review and all of that, and it's not done. Why has nobody taken on the whole Ridley bent, the whole thing, and taken it all the way up? Because of lack of funding. We can't get the funding. It could cost 60 to 70,000 to do it. However, there's a case very similar by the Friends of the Irish Environment, number C727 of 22, I think it is, and it's very slow. We're now into 2004 and it's moving very slow. That's against the whole program to an extent. Now, you might say, or you might ask, why do groups not use all this? Well, they have used it. And what we're finding is that when we use the SEA directive, they will cave in on some other ground so as to avoid making a precedent. So I've made you a video earlier about the nuisance aspect, which is a totally different thing. That's common law. The nuisance aspect is common law. But now we have a precedent set in the Dublin High Court. It has nothing to do with the European Union. But the fact that the SCA directive and the EIA directive and those directives have everything to do with the European Union. Well, in any event, another group in Belgium saw that the guidelines, which were issued in 2006, and it looks to me like the EU ordered every country to issue guidelines for building wind farms, just to avoid them maybe being 10 yards away from somebody's house or built in the middle of a local housing estate and all of that. And in 2006, most European countries brought out a set of circulars or guidelines. It doesn't really matter, and Ireland is one that did it and Belgium is the other. In any event, a group with a smallish wind farm in Belgium went all the way with it, and they went to the European Court of Justice, which ruled the guidelines are illegal if the planners act on them. 2, any planning permission granted must be annulled or removed. And thirdly, any existing wind farm built under the 2006 guidelines must be pulled down. Okay, I've explained that to you a few times before. So the problem facing anyone now going into court in Ireland is that you only had the European Court of Justice, so you had no backup country to adopt the same principle. And now the French, in the French highest court in France, has been applied to by a group who wanted to stop something over there, and the court has ruled that the very same copy and paste job for the case. The case in the European Court of Justice is C2419. You go into it there on search Curia and you get it, and you get the judgment. It's as I say. Now, this judgment is in the French language, so I didn't get it translated yet, but we have it from the groups over there. The French court has equally applied this case to the France situation. This means if you go into a court in Ireland, you can say, well, not only is this the ruling of the European Court of Justice, but it's also the ruling of the French highest court. So they already have a court to adopt it. And this has not been appealed. The French government is forced to put up with it any which way they like, and perhaps try and do some kind of a sham SEA. And they're going to find that very, very difficult because they can't prove the work at all in the first place. The Irish tried to update their guidelines in 2019, and the difference they had was, under the old 2006 guidelines, the setback distances between turbines and houses was 500 metres, and they increased that to 507 metres, which is absolutely useless, just done to show they'd done some little thinking about it and amended it in a wee way. That has been pushed on wind farm planning applications, but it's not going to work because it's as illegal as the 2006 guidelines. And anyway, they never completed the 2019 guidelines, and they realised, the stupid government in Dublin, and that I am right, that they can't do these guidelines without doing the proper environmental assessment, and that shows what actually they're going to do. They have to quantify all that, and these people are dog ignorant. All they can do when anything technical, anything building, anything engineering, or anything like that has to be done is hand it over over to a private company, like a company, to do it and tell them do the SCA, but they can't, because it has to be the government that does it. It has to be a competent authority that's appointed by the government, and that authority has to work under the rules of the SCA and prepare all that and go through the judicial reviews and fight the judicial reviews. And you know who they'll be meeting first up. First up, I can go all the way to the Supreme Court on these when it's an important matter. The reason I don't do so much of it is it's very time consuming, and I want to pick good cases. So now I think that explains. If you want to ask me any question, it's just another precedent set to prove that I was right all the time. Good luck. Comment underneath. Thank you very much. Or a thumbs up or a thumbs down, or argue any way you wish. I don't mind. Bye bye.